Hello everyone watching. Brighton Tajach is my name, and today the topic of emphasis it is going to be the contract of sales of goods and supply of services, and it is well governed by the Contract of Sales of Goods and Supply of Services Act. So by now we are going to discuss implied terms, or what we call conditions, implied terms and warranties. So you have to understand and put in mind that contract of sales of goods does not divorce. It does not divorce from the contract law. Yes, you have to put in mind that. So when you look, section 1 of the act, it defines the contract of sales of goods as a voluntary transfer of possession from one to another. So sale of goods, it is when someone transfers voluntarily to another person. But section 2, it gives a further discussion, a further definition that a contract of sales of goods is a contract by which the seller transfers or agrees to transfer the property in a good to the buyer for money consideration called price. So in such things, in such essence, there must be a consideration called price. When you put in mind, if you want to distinguish two things, a warranty and a condition, you have to put in mind that a warranty means an agreement with reference to goods which are subject to the condition. You have to put in mind that when you breach a warranty, it gives a rise to damages, but it does not give a rise to reject of the subject matter. However much in conditions, when you breach a contract, then it can rise to reject, or it can treat a contract as repudiated, as it was repudiated. So you have to put in mind, a good example is like when you sell a pen to me, then it is implied that you should not it is not expressed, it is implied that I should be knowing, and you yourself, you should be knowing that it must be writing. So when it fails to write, then it will treat the contract as it should be. So there you will give me the pen as it is expected. So in this essence, you have to understand that implied condition, where there is an implied condition, as we have said, as we have discussed it, there must be a good possession of title. So the owner of a good must possess a good possession. So go and read the case of Wilfred versus Kanga Limited. In this case, Kanga was the owner of the car which was sold to Muyingo. But there was a term of an agency in this. So the court held that the court presumed that there was a presumed agency. This comes in when you find that I have come into the bond and I want to buy a car, and I found someone there who shows me the car, the colors, the type of the car. Then once I pay him without paying the owner, and the owner went ahead and sued that person, for me, I will have acquired what we call I would have acquired what we call a better title from that person. Because for me, I didn't know that For me, I didn't know. I just knew that that person is the owner of the bond. So I went ahead and I bought that car. So there are some elements that you must put into consideration, or you have to put them in mind, that there must be what we call a quiet possession, and there must be no encumbrances. So for a quiet possession, that yes, the person who is selling must be. So a quiet possession, that I have bought something from you, but I'm hearing some quarrels from other side. So it must be clear. It must be a little bit of peace when I'm buying that certain thing. So when you look at, there should be free from encumbrances. But for me to acquire a better title, then there must not be encumbrances. Let's say mortgage, lease, any other encumbrances. Also, enkayana. There must not be enkayana from that certain good that I'm buying. So when you go back and look about the implied warranties of a quiet possession under section 13 clause 2, that the property that you are transferring must be yours, not the pressure as if you've stolen it. So it must be presumed it should be yours, that what you're transferring is really yours. There should be no pressure outside. So when you look at the case of Mawson versus Burnham, the subject matter shall be remain without an external or interruption or disturbance. So you have to put in mind that. So when you look at section 13 clause 4, it talks about freedom from encumbrances, as we have said. And as we go further, let's look at what we call other implied warranties. When you look at section 14, which clearly shows the sale by description. Sale by description, it means that the description must be the same with the bulk. A good example is like when I ordered the Samsung Galaxy series 128 GB as described by the seller. If I found out that the phone is another model, then I can reject it. So that is a good example. Now, when you look at section 15, for it shows where the quality and the fitness to purpose, or the quality and fitness for purpose. So in this essence, they are telling us that the purpose must be disclosed by the buyer. So when I come into the shop and I say I want this, then sometimes if I want something, I have to disclose its purpose. So when you look in the case of Hewlett versus Company Limited, 1932, the seller ordered a packaging cloth, but for him it did not specify the purpose. So the seller supplied it, but it wasn't suitable for the purpose. So the court went ahead then and held that the seller wasn't liable because the buyer did not specify the purpose. So this means that once the seller comes in and ordered something, then he must specify its purpose so that it can really fit the purpose. So they are telling us that where a sale is by sample, the bulk must be similar for the sample. That is section 17. The item sold, if the sample and the main bulk does not identify the sample, then the buyer may end the terms. Which means that when you give the sample to the buyer. The sample must identify with the bulk. A good example is like when you give me a pen from a certain band of pens, and you say this is type this, then if you're giving me that bulk of it, then it must be similar. So that is what the section is telling us. So when you look at section 18, for it shows how basically it talks about the suppliers must perform services with reasonable care and skill. So when you look at it, it talks about the reasonable care and skill. The care and skill must be reasonable. And for this, the standard expected of a given a reasonable competent provider in that business. So the standard is expected as reasonable as the reasonable man states. When you look at the Bolam case, the Bolam versus Hospital Management Committee, that case, the test you go, we look for someone who is in the same business, who is the same skill, then we test if it should be like this. When he comes with a different answer, then we impeach or we can sue for damages. So that's what the section 18 is talking about. So as we have said, for a condition under section 1, it is defined as an agreement with reference to goods which are the subject of a contract of sale, but collateral to the main purpose of such contract. So in this, the breach arises or gives to the rejection to the good and treat goods as repudiated. So once a condition as a condition happens, we treat the contract, we set it back as the way it should have done. Take an example. I have ordered that you send me a bulk maize flour. By the end of it all, I'm seeing you are sending another type. It is not maize, it's another type of flour. Then we have to treat. I can reject. Then you can reject the same. So that is how the contract of sales of goods and basically the implied terms and implied conditions, how they are treated. Thank you for watching. Thank you for listening.